thanks Gautam for joining us today. The first question that we want to ask you is about the minimum wages requirement. Both BluSpring Enterprises and the university has continuously cited that both the enterprises pay the workers much more than the minimum wages requirement of Haryana state.
Yeah.
Do you think that invalidates the protest and the demands of the workers?
Well, no, because there are two different issues. One is that every individual has a constitutional, a fundamental right to a minimum wage, Article 23, which is enforceable against both the state and private parties. So that is one issue. But the other issue, which from what I gather is the important one, is that you now have spent 10 years on contract labor. There is no regularization because there is this outsourced contract. You don't have obligations you can enforce against the university. Many of those obligations under the Industrial Disputes Act. And that is, I think, at the heart of the issue. So minimum wages is just one amongst an entire bucket of labor rights that the statutory framework guarantees, but is being denied because of this outsourced method of bringing in people to work. And so I think all of that is completely independent of minimum wages and is equally, if not more important than minimum wages. Now, the other thing is that also worth remembering that minimum wage is literally the wage that in law is enough to keep the body and soul together. There is a concept of a fair wage, which is actually much higher than the minimum wage, and that is the wage that you get so that you not just keep yourself together and can reproduce yourself, but can live a dignified and decent life. And the only thing is that the minimum wage is a constitutional right. It is still legitimate to ask for a fair wage, and so that's why just that you bring minimum wage is just basically it means that your employer is adhering to the bare minimum threshold under the constitution, but that is not what you have to end with, because you can always ask for something more, which is the fair wage, and that's the international standards. The UN has a definition, and so that's quite the right thing to ask for.
And just to follow up on that, what are the legal arguments that one can make to ask for this fair wage?
Well, so I think the main argument is technically not, it's not in the minimum wage category, but broadly, historically, when you go to court and say that, look, we have been on contract for these many years, we have not had proper increments to keep up with the cost of living, and they are using the fact that it's a contract to deny us that, therefore we should be, entitled to that kind of increment. That's a legal argument people have made. And a large part of it actually rests upon demonstrating that you are employees of the principal employer, because a lot of this is much harder to ask for when it is just a contract, because the assumption of the law is that two independent parties have signed the contract and that's what it is. But of course we know that's not the case, and that's why, as I mentioned when I was talking to them over there, that there is the idea of a sham contract, right? So where the kind of work you do is so integral to the functioning of the organization, the university in this case. You have been working for years. Your work is regular, it's daily, it's frequent. And then if you were to outsource to a third party, then basically it's what we call a sham contract. The real employer is the university. The real employees are the workers, and you interpose this body in the middle to evade obligations. Then the court will declare that this is a sham contract, and that's one way to go. And once if that happens, then all the rights that are there in the Industrial Disputes Act become available to you. And then you can claim increments and so on, and you can say they've been working for many years. All that then becomes part of the industrial dispute. The other good thing is that if you raise a dispute, then you can't be sacked, right? So there there can be no action against you while the dispute is still on.
Right. Since you talked about fairness and a fair wage, the workers have been out on strike for over 8 days now, and they've received at least 2 rounds of show cause notices about unauthorized absence and for termination. Now, 2 questions are there. A, can BluSpring Enterprises legally withhold their salaries for these 8 days? And second, can they refuse to recognize this as a protest?
Yeah, so this is a bit of a grey area, because unfortunately the courts have said that there's no right to strike. So there's no constitutional right that you have to strike under the constitution, and there are again procedures under the Industrial Disputes Act that where you can raise a dispute, and then if it's not resolved, you can call a strike, and that's a legal strike. I think it depends really on how you classify what's happening. So I would say that it is a protest. It is dissent against the policies, and that is completely legal and valid. It's an exercise of your 19(1)(c) rights. and that is therefore a valid expression of protest and expression. I think like the problem is where that becomes or is called a strike, and there then you have to actually ask for that payback, which is a little harder to do, I think. So I think like there the law is unfortunately a little hostile for certain reasons, and it doesn't look kindly upon strikes. But if it is a protest, then that's a different matter, and that of course is something that there is a constitutional right to do.
And just can you talk a little bit more about what you spoke about strike not being a constitutional right, about the constitutional legalities in terms of the difference between a protest and a strike, and then what can be done if the workers' salaries are being withheld?
Well, so I think like the best, like I said, the difference is that strike is literally like abstaining from work, right? That's sort of the non-technical definition of a strike. Now, normally what happens is in these kinds of cases is that the employer will then file a case against the workers, why them go back to work, all of that. Here that's not the case. Here they're withholding the pay. So I think here perhaps like the best way is to argue that it's actually not like a strike. It's it's just protesting against the policies of the company, and that is protected activity under the constitution, and you can't deny someone wages for that. But I think it's a little bit of a grey area. It's a little hard to really argue, because if you are abstaining from work, then technically, in normal terms, that would be called a strike. So we are really creative to ensure that doesn't happen in this case.
Gautam, perhaps the first final question that we would want to leave you with is the possibility of a union, and if unionizing can solve some of the problems that this strike is symptomatic of. Yeah,
so the good thing about a union, well, there are two things. One is that, of course, a union gives you more bargaining power, so you're negotiating collectively and not as an individual, and it is then possible to get some of those things in a better way. The other good thing is that it is always easier for a union to raise an industrial dispute than it is for an individual. And what happens is that so of course if you raise a dispute, the university and the BluSpring will argue that look, this is a contract, they're not involved, all of that. But that will have to be adjudicated properly, in the appropriate forum. Now, while a dispute is on, there can be no punitive action taken against you. So, you can't be, your pay can't be withheld, and you can't be fired. They can't bring in, substitute labor, all of that. So, raising the dispute protects you, at least while it is in progress, from the more punitive aspects of what the employers can do to workers they find creating a nuisance. I think one thing to keep in mind, well, two things I think. One thing is that all of this will take a long time. So, these are all very long, drawn out, painfully slow processes, because the Indian legal system works very slowly, so that's one thing. And the other is that there's a lot of uncertainty in how the law will go, right? So I can tell you the law says X or Y. It may happen that it doesn't happen actually in court, and we all know that, right? So there's always a risky enterprise. Once you take something from the realm of the protest and dissent to the realm of the courts, there's always a risk in how they will choose to interpret or apply the law. So keep that risk in mind when you're thinking of the ways forward.
And just final question. How can the workers start unionizing, or how can they begin to form a union?
So I think the best thing, so there are many specialist labor lawyers who can do this, basically at no cost. It is a very easy process. You don't have to have a majority of the workers, any number can get together, fill the form out, and say we are the so-and-so union. So it is a very straightforward process. It doesn't take too much of a time to initiate. And the best thing is to have a specialist labor lawyer who will just do that for you, and it's a very easy process in that way.
Thank you so much.
Thank you.
Thanks for joining us.
Thanks.